Let's keep going with the contract discussions. Just a few more things to really get into before we switch gears to the more specific side of contracts. We've already talked about the statute of frauds back in the deed section, and I've already started teaching it in the contract section. And it's important because there are certain documents, as we said, that are so sensitive, so important that we would not consider them enforceable in a court of law unless they were in writing. But you've got to listen and understand that not every contract checks that box. There are so many contracts that are absolutely enforceable, even as oral agreements, even as implied agreements. But certain ones that are so sensitive have to be in writing to be enforceable in a court of law. Deeds, right? Or I guess it's not even just contracts because, certain documents in general, should I say. So deeds, contracts for the sale of real property, mortgages, options, easements, leases in excess of 3 years, all of the above. And restrictive covenants as well. And then remember, aside from the statute of frauds, there was another piece of legislation that kind of was grouped similarly that said certain things need to be recorded to protect your interest from third-party claims. What was the name of that piece of legislation? What do we call that one? The recordation was what? There you go. The Connor Act. The Connor Act. Statute of Frauds deals with writing. Connor Act deals with recordation. The lists are basically identical under each of those two pieces of legislation. It's just one is in writing to be enforceable in a court of law between the parties, and the other one is recorded to protect against third-party claims and to protect your interest, so on and so forth. Now, one of the biggest parts of the statute of frauds is it does state, certain things have to be present in these documents, like the subject matter of the document or the contract, the names of the parties, the expectations of the parties. And so when it really gets down to it, there is what they call in the statute of frauds, the parole evidence rule. And the parole evidence rule states that only what's in the contract is part of the contract. Anything that's not in it is not part of it. So let me just equate this to real estate for you, okay? Folks, do you think that a washer and dryer is real property or personal property? Personal property. And so imagine that I put in an offer on behalf of a buyer client and we don't ask for the washer and dryer, and we put in an offer. The seller accepts the offer as written, and we form a contract. Folks, since we didn't ask for the washer and dryer, what is the default for the washer and dryer? What's going to happen to it by default, most likely? Yeah, seller's going to take it with them when they move out. Now, let's say in the midst of our contract to close period, we have oral discussions with the listing agent and the sellers, and the sellers say, oh, well, we're actually planning on getting new ones, so we'll just leave them in the house for you. Everybody following along with me here? The seller says, we will just leave you the washer and the dryer. And we get there on the day of closing, and the washer and dryer are gone. Do we have any recourse? No. Because it wasn't in the contract. That's the parole evidence rule. Only what's in the contract is part of the contract. If we wanted to be able to have recourse, could we have amended, there's that word, amended the contract and put it in there that they were staying? Sure, we could have. But if we didn't do that, if we just left it as word of mouth, it's not enforceable because it's not in the contract. Does that make sense for everybody? Oral agreements outside of the contract have no legal standing in a court of law. If we ended up going to court over this contract, it's not part of the contract. It was an oral agreement outside of the contract. That's the parole evidence rule. Only what's in the contract is part of the contract. So if it's important to you, put it in there. Now let me introduce some language with contracts, folks. Time is of the essence. We're going to get into in great detail in the next section, but time is of the essence is basically a legal contract concept that states there is no wiggle room. The date is the date is the date. The time is the time is the time. No ifs, ands, buts, or coconuts, as I like to say. Now, not everything in contracts are time is of the essence. Some things have wiggle room. And we'll talk more about that in a little bit. But when we say time is of the essence, there's no wiggle room. Get it done when it's supposed to be done, or else. Now, when we're talking about contracts, there's two big terminologies that are also testable, and that is an assignment and a novation. An assignment is a substitution of parties. And while this is not exceptionally common, you do need to understand this. And so don't worry about why, just worry about what. So for example, I offer to buy Cheyenne's home for $400,000. And she says yes. And we have a contract in place. And in the midst of being under contract with Cheyenne to buy her house, I have a conversation with Beverly and find out that Beverly is also extremely interested in this house. And I said, well, you know what, Beverly, I've kind of changed my mind on buying this house anyway. So what I'll do is I will just assign this contract to you, and you can buy Cheyenne's house. The contract itself didn't change. What changed was the parties. Instead of Seth Chauncey buying Cheyenne's house, Beverly is now going to be the buyer. I have assigned her to be the buyer. That is an assignment. Contract's the same, but I have substituted out a party. I've assigned it to him. Don't get so caught up on why that would happen, folks. It does happen. Let me give you a real world example of when this was happening. During COVID time, when the interest rates were low and every house was a multiple offer situation, people kept getting beat house after house after house in these multiple offer situations. And some people got tired of it. And so some people, after they got beat, would actually find out who won. They would call them up and they would offer to pay them $30,000, $40,000, $50,000 just to have them assign the contract to them because they were tired of losing out on the house. And so that's a way that this could happen. So an assignment, the contract didn't change. Cheyenne is still selling her house for the same amount of money. It's still being bought for the same amount of money. It's still closing on the same date. But instead of Seth buying it, Beverly's buying it. Does that make sense? That's an assignment. This can happen in leases. This can happen in contracts. It can happen in a lot of different things. But it is a substitution of parties. That was a crazy time. You're absolutely right. I mean, part of me kind of misses it. Part of me is kind of glad it's gone. You know, it's like a double-edged sword because like the economy could not have, the housing market would have had an issue if that kept up, right? It needed to have a cool down for sure. So now a novation is a substitution of contracts. Think of it this way: out with the old contract, in with the new. And I'll give you two examples of this. Okay. Folks, legally speaking, once you have a contract in place and all parties have signed and communicated and you've got the terms on it, you know, $400,000 and, you know, purchase price, $2,000 in due diligence, closing date of December 20th, you know, whatever the terms may be, once it's actually signed and communicated, you could actually make amendments just like you would counters. Because now that it's an executory contract in place, if all parties agree that, you know, hey, we're going to change the closing date from December 20th to maybe we'll move it up, December 15th. All parties would just initial and date it. And as long as we show this mutual agreement to change the date, we have amended the date. Everybody still okay with this, what I'm saying here? Well, sometimes because of a lot of different reasons, we will make a lot of changes on contracts. Now, we have a form to amend it so it doesn't get sloppy. But I mean, what if we came in and we changed it to, you know, 3,000 in due diligence and people initialed and dated and signed, and we changed this to 405,000 and we initialed and dated and signed, and then maybe we changed it back to 400,000 because it had appraisal issues. And then we initial dated and signed. Folks, at a certain point, it's going to be so mucked up that nobody even knows what we're agreed to anymore. So here's one example of a novation. We could say, well, hey, listen, this thing is getting crazy. I'm going to type up a new one with all our current terms on it. We're both going to sign it, and we're going to pretend this other one doesn't exist. That would be an example of a novation. We have killed the old contract, replaced it with a new one. There's one example of a novation. Let me give you another one. If I have a commercial building and Savannah leases a commercial space to open a cupcake shop, okay? We'll call it Savannah's Cupcakes, or whatever you want to call it, Savannah. It's your cupcake shop. And she has a 10-year lease with me to lease this commercial building for her cupcake shop. And 3 years in, her cupcake shop is just doing so phenomenal that she ends up selling the business to Jack. Jack looks like he wants to own a cupcake shop. So Jack buys the cupcake business. And so Savannah calls me up and she's like, Seth, I'm selling the business. I got 7 years left in the lease. Do you just want, to assign that lease to Jack as the new owner? And I say, well, no, Savannah, have Jack give me a call and I'll negotiate a new lease with Jack. So Jack calls me up and I negotiate a new 10-year lease with Jack. And so because I've got this new 10-year lease, I'm going to forgive and forget the old one. That's a novation as well. New contract, forget the old one. Is everybody with me? Could be the same parties, could be different parties. All we know is I've got a new contract and we've mutually agreed to kill the old contract because we've got this new one. Novation versus assignment. Now, throughout our agency discussions and the beginning discussions of contracts, I have told you the best way for any contract to end is what?
Fulfillment.
Yeah. We call that full performance. Because the contract, right, is where we've made these legally enforceable promises to each other. Once we have a contract, we expect you to perform, right? Performance is what you do when you have a contract. And so the best way for any contract to end is full performance. In the way of a real estate sales contract, house being sold, seller getting money, fully performed. In a listing agreement, we sold their house, we got paid, fully performed. In a buyer agency agreement, we helped them buy a house, we got paid, fully performed. That is the best way for any contract to end. So full performance kills a contract. There is also what we call partial performance, sometimes referred to as substantive performance or substantial performance. It's where you got almost everything you were promised, but you didn't get everything and you just said whatever. Folks, do you think that ever happens? Do you think there's ever times that a seller was supposed to leave something and they don't, and the buyer's pissed off about it, but it's just like, it's not even worth worrying about, so they just close on the house anyway? Yeah. That's partial performance. And so let's say that the seller was supposed to leave, I don't know, maybe we negotiated a bookshelf. And it's in the contract. And the seller takes the bookshelf with them. Well, you could take them to court because they are now in breach of the contract because they didn't give you everything they were supposed to give you. But is a bookshelf probably worth going to court over? No. So most buyers are probably going to be pissed off, probably going to grumble about it, but ultimately they probably will close. That would be partial performance. They closed, but they didn't get everything they were promised. Now, of course, anytime somebody's not giving you what they promised, that is considered a breach of contract. And so we've already talked about this in the past too. If one party breaches, that gives the non-breaching party typically the right to get out of the contract. And a lot of times with penalties to the breaching party. So if somebody breaches, the other non-breaching party can get out. Other ways that contracts could potentially end, we've kind of talked about some of these as well. Impossibility of performance. You can't do what you said you were going to do. Like the house burns to the ground. You no longer have the ability to convey the house as contemplated. Or the house is foreclosed upon prior to the closing. Or, buyer can't obtain financing. Yet again, doesn't mean you're not in trouble. But the contract would end. There would typically be some penalties for whoever's at fault here, unless no one's at fault. And then it would kind of be let bygones be bygones, return everybody to where they were. Of course, mutual agreement, we've said already, will kill every single contract. Doesn't matter which one. If both parties agree to kill the contract's dead. No ifs, ands, buts, or coconuts. Every contract dies with mutual agreement. And then, of course, operation of law, folks. If the home is taken by eminent domain, that would kill it. If it is, taken by way of a court proceeding, a lien, seized by the police, anything like that could kill a contract as well. Also, arguably under impossibility of performance. So when a contract doesn't happen the way that it's supposed to happen, when somebody breaches, we said that these were potentially enforceable. And so we can either A, enforce them, or B, be entitled to what we call remedies. Remedies is, well, let's make it better. Kind of like an old school remedy. Like you were sick, they gave you like vodka and cocaine back in the day, right? That was the remedy back in like the 1920s, right? Got a cold, vodka and cocaine, rub it on your teeth, you'll be fine, right? And a day or two, you'll be just having a good old time. Oh man, what a time it would have been to be alive in the 20s, right? I'm kidding. I bet it was not great. So when we're talking about remedies, the most common is going to be monetary damages, is what we call them. Monetary damages. Monies. Because you've been damaged, you get some type of monies. We call those monetary damages. The first one, it's not bullet pointed out fantastically, but the first type of monetary damages is called compensatory damages. Think of that root word, compensate. If you are going after somebody for compensatory damages, basically you want them to return you to the financial position you were in before they breached the contract. Whatever you lost, have them reimburse you for it. It is an identifiable amount. Because of your breach, I've lost $10,000. Pay me $10,000. That is compensatory damages. Being reimbursed for your loss. Another type of monetary damages that exists is called liquidated damages. This one right here. Liquidated damages are a pre-negotiated amount. It says, okay, we're entering into a contract. If I mess up, here's what you get. Now, folks, when we get into our North Carolina specific contract, probably tomorrow, you will hear me talk a lot about earnest money. Earnest money is an example of liquidated damages. It is a pre-negotiated amount that says if the buyer breaches contract, that is what the seller is entitled to get. So liquidated damages, pre-negotiated amount. If I mess up, here's what you get. Earnest money being an example of liquidated damages. The last monetary damage is called consequential damages. Consequential damages. Root word being consequences. This is seeking damages for future or lost profits. It's not necessarily an identifiable amount. You didn't lose this amount of money on your bank account, but you lost the rights to money because of something somebody did. Best example I can give you, not real estate related. Y'all remember the Johnny Depp Amber Heard trial yet again, right? When she made all those defamating, statements about him, he lost out on a bunch of movie roles, which was a huge amount of lost profits. So he countersued her for consequential damages. All the money he lost because she said crap about him that was arguably not true. And so if it was to be equated to like the real estate world, if you bought a turnkey Airbnb and after you closed on it, you found out that you couldn't lease it for like 30 days, you could potentially sue somebody for consequential damages because you thought you were going to be turnkey and it wasn't. It's also kind of the same thing as when people get in horrible accidents and they're paralyzed. They sue the companies and the insurance companies for consequential damages because they've lost out on a lifetime of being able to work now that they're disabled. So, future lost profits. So of the monetary damages, right? Compensatory, return me to the financial position I was in before you did me dirty. Liquidated, pre-negotiated amount. If I mess up, here's what you get. Or consequential, suing them for future or lost profits. Not necessarily an identifiable number, but you've been damaged and you've lost profits due to their actions. Now, there is another contract remedy available that is not monetary. And that is called specific performance. Yet again, performance being what you're supposed to do when you have a contract. You have contract, you perform. And so specific performance is a lawsuit where you take them to court and you force Judge Judy or Judge Joe Brown to make them do what they said they were going to do. That is specific performance. You take them to court and you try to force the judges to make them do what they said they were going to do. Word of caution, though, on specific performance. Okay, listen very carefully here. Specific performance, from a basic contract law point of view, is arguably for anybody. However, if we are talking about the offer to purchasing contract standard form 2T in North Carolina, which is what we're going to get into tomorrow night, only a buyer would be able to sue a seller for specific performance. A seller does not have the right to sue a buyer for specific performance in North Carolina if you're using our standard form 2T. So in general, it's for anybody. But it's only available to a buyer if you're using a specific contract in North Carolina. You know, it's funny, whenever we have these like couple chapters back to back, I can always see the time when your brains start to just like shut off. Because it's just so much information. And it's always been so much information, but sometimes it at least kind of goes back and forth. But this has just been like, and this, and this, and this. And I can see your brains all shutting off right now. I can see it. Every single one of you. Some of you look more distraught than others. Barry looks tired. Chelsea's doing the hand on the head thing, which, you know, tells me she's just like, you know, it's the gift that keeps on giving, Chelsea. Tara arguably looks like she's still thinking about that wine that she's going to drink. I'm convinced, Tara, the bottle's on the other side of the screen, so you're just like looking at it, right? Like making eye love with the bottle of liquor, Jack Daniels. You're just like, right? You're just like talking to... Yeah, I get it. Tequila. There you go. That's why I said liquor, wine, something. There you go. Tequila's never a bad choice. Yeah, Raphael's typing something. You look like you were struggling too, Raphael. I didn't get to you yet. You were like laid back in your chair like, I don't even have the energy to sit up and listen to this, man. Like you were... That's where you were.
It's easier. I was tired, but man, I've been in day crew or night crew for the past 3 days, so I'm floating.
You know, I sympathize. That was me on like Thursday and Friday. I was taking that stuff like it was candy.
Well, yesterday I was here sitting down and I was like in a fever, like I don't know what it was, but it was like 90 something, 101 or something.
Mm-hmm.
So.
Yeah, it's that time of year, man. Everybody gets the ick. Oh man, I hate this time of year. It just gets passed around and it's just gross. Yeah. Thank God it's all via like Zoom. None of us, you know, like have to get exposure to anybody else. But still, the rest of life is not as friendly, not as zoomy. How's everybody feeling out there, right? I mean, I basically just called you all out that like were standing out to me as like you wanted to like stab me in the face. But how's everybody feeling? Everybody doing all right? Okay, so like you got to clarify, Antonia, because you're either saying good with like a lot of emphasis or you're saying God with a lot of emphasis. And those mean two completely different things.
Good God.
Good God. Which, both combined. Okay. Tired. I get it, Brooks. Yeah, tired is a good way to put it. The 8 group questions hurt my feelings. Yeah, I hear you, Jack. That they have a tendency to do that. Yeah. The group problems. That's why I like to include it. Unfortunately, though, that is such a specific lesson that I can do exercises like that. Like, there's really nothing I can give you like that for a lot of these other things. Plus, as I said, y'all figure this out. It's the gift that keeps on giving. I have to keep talking because 80 hours, and I could still teach you another 80 hours. I mean, it just keeps going. So, But sometimes I like to derail because when I see the anguish, I'm not really getting much information into your head. So I like to stop and just talk to you for a minute. Paige, you seem chipper. You feeling okay over there?
Yeah? My brain is hurting.
Yeah? Right well, you hide it well, Paige.
Thanks.
Yeah. She seems fine. Right? She's just... Even in pain, she's just smiling. Just, yeah, this hurts. This sucks. It's fine. Beverly, how are you over there? I have to ask you. You're typically very vocal about it, so...
Making it.
Making it. There you go. Okay. All right. Just a little bit more tonight. I promise. Last thing on here, last two things. The last one says subject to the statute of limitations. Folks, there are certain things that time out after a period of time. In other words, you have to go after these damages within like a certain time frame. Like you wouldn't be able to like accept the contract, close on it, and then go after somebody, you know, because you didn't get that, you know, bookshelf 2 years later. Like there's a statute of limitations on when you can do these things. But rescinding the contract is kind of an interesting one. I'm going to say that's arguably probably the least testable, but to rescind the contract is to basically say that it doesn't exist. In other words, it's kind of very similar to voidable. You kind of take a look at it and you say, okay, well, let's just go back on it. And because this is not what we thought it was, there was something not present. And if all parties agree, rescinding the contract's easy. Yet again, if all parties don't agree, you're back in court with the same as like voidable. So to rescind the contract is to try to say that we didn't have one in the first place. It's very much a similar concept as voidable. But you're not going to really be as tested on things like rescinding the contract. That's different than revoking an offer. The other thing you have to understand too is if you rescind the contract, you're not entitled to damages. That means you didn't have a contract and you just want to be back to where you were. If you have a contract and somebody breaches, you're going after them for damages, these remedies that we're talking about right now. And those wouldn't be available to you if you said there was no contract. So here's a question for you, and I've already kind of walked you through this one, so hopefully every single one of you gets this one correct, and I'll just be quiet and let you read it, because I'm sure I'm hurting your brains. By the way, the EMD stands for earnest money deposit. So let me help you out with this because I think there's a little bit of confusion as to what exactly is happening here. Buyer and seller have verbally agreed for the seller to leave their washer and dryer, although this is not included in the offer to purchase and contract, which means it's not in the actual contract. The seller later decides to take the washer and dryer with them to their new house. The buyer is distraught and wishes to terminate the contract. And the question is, the seller will be entitled to the contract remedy of the earnest money deposit if the buyer breaches the contract. Yeah. Because the buyer breaching, I told you, earnest money deposit is a type of liquidated damages. It's a pre-negotiated amount that says, if the buyer breaches, this is what you get as a seller. And so if the buyer terminates over a washer and dryer that was not even part of the contract, the buyer's in breach, which means the seller is entitled to the earnest money deposit as damages for the buyer breach. Does that make sense? Now, of course, this is kind of a newer concept because you don't really know all the details on the offer to purchase and contract. But in a nutshell, the buyer breach is what you really need to take away from this. And the earnest money deposit, if present, is entitled to the seller. Seller is entitled to it for that breach of contract. Last big thing on this section, and when I say big, it's really not big at all, but it's the last thing, and we'll wrap up chapter 9, if you will. When we're dealing with auctions, folks, a couple things to be aware of. Beverly, I'm sorry, I just saw your thing in the chat. Even with a verbal agreement, what do you mean?
Was this, it looks like they had a verbal agreement, and I thought you said, maybe I'm tired, I thought you said it had to be in writing in order to have any sort of contract remedy or something. I don't remember.
Yeah, it had to be in writing for it to be part of the contract. And so that's what you got to understand. Since it was just a verbal agreement, it wasn't part of the contract. So if the sellers took it and it was part of the contract, the seller would be in breach. As it were, it's not part of the contract. The sellers took it. They're not in breach. But if the buyers decide not to buy the house over something that wasn't in the contract, the buyers are in breach.
Okay.
Yeah. So auctions, folks, can we all agree that sometimes real estate is auctioned off? Everybody agree to this? Sure, it happens. And so I'm sitting here telling you in North Carolina that you have to have a contract for the sale of real property in writing. Well, folks, imagine how that would work if you were trying to do that at an auction for real estate. It doesn't make any sense. Like, what are you going to do? Like, stand there with a piece of paper and like try to fill it out while the guy's yelling 200,000, can I get 225, 225? It's not going to work. And so there is special understandings for auctions that when somebody, the auctioneer, bangs the gavel and says sold, it's as legally binding as a written contract because of the nature of auctions. It will ultimately be reduced to a written contract, but it can't start out that way because of the nature of auctions. So there's piece number one. Number two is understand that anytime that real estate or real property is being auctioned off, the auctioneer firm who's auctioning it would have to have both an auctioneer's license and a broker's license, because they're auctioning off real property and they're auctioning in general. So they need a real estate broker's license and an auctioneer's license. Now that does not include the mere crier. I don't remember if you remember when we talked about this on like day one. The mere crier is the person who talks really fast. They are an employee. They don't need a license, but the auctioneer firm does. The last piece of auctions that you may need to know is auctions typically operate with what we call with reserve versus without reserve. With reserve means we reserve the right to not sell if we don't meet a certain price. It's basically got like a minimum number. Without reserve says we'll sell it for whatever price we get. Now, here's the good news. That's the end of that chapter. The bad news is while that chapter is over, I told you, it's one of the most testable. There are so many different ways they can spin all of those contract terminologies on a test question. Because you can have questions on when does an offer become a contract. You can have a question on revocations. You can have a question on bilateral versus unilateral. You can have a question on damages. You can have, there's so many different things that even that small amount of information could be spun into so many different questions. So that was the bad news. The good news is that chapter's over. Yay. Sometimes I just feel bad, right? Like I told y'all, sometimes I just feel bad. Because like I know I'm just sitting here torturing you and I have to. It just makes me feel bad. I don't enjoy torturing you, okay? If you think I do, I don't. I'm sorry. Anthony, don't you... you stop it. Okay, don't you call me a liar. I'm a nice guy. Most of the time. It gives me no pleasure to cause y'all pain. I promise. It's just a necessary evil. So let me explain. That's right. I'm just preparing you to be great. More than anything, I'm preparing you to pass the test. That's what I'm really doing. And then I'll prepare you to be great brokers and post licensing. But got to build that foundation first, right?